And we are next speaking with Richard. Richard, go ahead.
Hi, how are you?
Good, Richard. How are you doing?
Fine, thank you.
How can we help today?
This question involves the fact that I'm separated from my wife.
Okay.
A court order was issued early last year in which our son spends the vast majority of his time with his mother. Basically, I'm just wondering what's involved in changing the court order such that our son would spend half his time with me and half the time with his mother. Everything's been complied with concerning the court order, such as child support and that kind of thing. What can be done to change that court order again so that he spends half his time with me and half his time with his mother?
Well,
thank you, Richard. And
Richard,
Andrew, go ahead.
My first question for you is that order that was made last year, was that a temporary order or a final order?
It said final on it.
Okay. So to begin with, you could bring what would be called a motion to change. But typically, without seeing the court order, and there could be something different in your court order, but typically that order is subject to a material change in circumstance. So you would need to establish that a material change in circumstance has taken place. That's the threshold question for you to reopen the door to change the schedule. What could be a material change? It has to be something about your child. So for example, a new partner has moved into her home. There's been a significant move that may impact the time that your child can spend with you. Meaning if you lived in Scarborough and she moved to Etobicoke and the commute is extensive, and you were able to provide your child with the same school because you're in the same school catchment she was. There has to be a unique set of facts that triggers a material change. Without a material change, you're going to have a real hard time being able to change the schedule, especially when the court order is really fresh. And what do I mean by that? The court order is only a year old.
Well, perhaps in Richard's case, what if his child says, well, no, I want to spend more time with Dad? Can that help? That can't influence anything?
The older the child is, the more influence the child will have. But the problem is, this is a court order that, from the sounds of it, is just about a year old.
Okay.
So that in of itself is going to create a problem because the order doesn't have a lot of traction. Now maybe the order isn't working. Maybe you have a child that was an A student or a B student, now the child is doing terrible in school. Maybe mother is spiraling out of control on alcohol or drugs. All of those things may be material change, but that's the threshold issue. If we're talking about a 16-year-old child, then that 16-year-old child will probably choose with their feet where they want to go, meaning the child will say to Mom, I'm going to stay with Dad.
Okay. So the age, a material change, Richard, is very important for you to take note of. Does that help answer your question?
Yeah, the last point, though, that the lawyer made is of interest. He, for example, the day he turns 16, which is not too far away, can he just unilaterally say, I want to change to 50-50, for example, without having to issue the motion for change? Or in other words, when a certain age is reached, does the process change?
Well, there isn't a set age. It depends on the maturity of each child. So one child could be 16, another one might be 15. Problem is the courts do not want to see parents lobbying the children for a change. And you have to remember something about kids. Kids want to make Mom happy, kids want to make Dad happy. Kids have a good idea what we as parents want. So kids may very well tell Dad they want 50-50 and may very well tell Mom they want the schedule the way it is. So if you're thinking at age 16 your child wants to live with you, before you go take it back to court, depending on what the relationship is like with your ex, you may want to think about alternatives. For example, you may prefer the idea of both of you jointly hiring a social worker for your child to go talk to the social worker in order to express where he or she wants to go live. That's vastly less expensive than going to lawyers and a lot less difficult and stressful for both of you and, most importantly, for your child.
All right, Richard, thank you so much. Hopefully that answered your question. Again, we have lots of callers that we need to get to, Richard. So hopefully that points in the right direction. Please, best of luck. And we're going right on to our next caller. Adam, go ahead.
Hello?
Hi, Adam. Thank you for being so patient. Go ahead.
Hi. I wonder if the attorney could speak a little bit on if one partner is the primary breadwinner they split up, what is their obligation to help their ex-partner pay for legal representation if they don't really have the means to do it themselves? And what's your advice in, navigating that?
Wonderful. Thank you, Adam.
What you're really calling under the rules, we call that interim disbursements. And that's where the concept is the court wants to level the playing field between both sides. And that means if, for example, you're the primary breadwinner, your wife could go to court, or your former spouse can go to court and say, I need some help in paying the legal fees. The court could call it just a payment. The court could call it an advance against a future payment or a loan. There's a lot of discretion. It's hard to know the facts of your case because a court may also make an order for you to pay spousal support. And once you're paying spousal support, she may not have a need for that interim disbursements. You both may own a home together and you may have a line of credit. And if you have that line of credit and there's a lot of available money on that, you may turn around and say to your wife, I don't want to pay your legal fees, but you know what, we have a $300,000 line of credit against the home. I'll let you access $50,000 of it, you pay the interest on it, and go pay your legal fees with your own money, and then I don't have to pay for it. So there are strategies that depend on your unique circumstances to try and rebut that argument.
Would a financial advisor be helpful for Adam? Who would be helpful in trying to determine?
What strategy?
Yes.
A good divorce lawyer really can take you through and navigate you through that particular problem. In order to do that, you would need to see your financial statements and her financial statements, but keep in mind, the interim disbursement claim can only be made once you go to court. If you're not in court, then you don't necessarily need it, but if you get an agreement and she doesn't have a lawyer and you haven't given disclosure, that agreement will be subject to attack later on, and there'll be a much better chance of it being set aside or overturned for the reasons of lack of independent legal advice or lack of financial disclosure. So if you have to pay her a little bit in the negotiation to cover her lawyer to get you that deal, that may be well-spent money and a lot less expensive than having a subsequent battle a few years from now.
Adam, does that help answer your question?
So it's reasonable if I'm paying her legal expenses, I can basically credit that as an early disbursement of support payments I'll be making later.
You need to get it in writing that that's what you're doing, or in the alternative, if there's property and she's going to get a share of the house, you say, that's against your share of the house and you'll pay it to me later.
Okay, so it can be applied in some sort of way.
Yes.
Okay, and you said something that was interesting. You need to have it in writing?
Yes. If you're going to give an advance and you want credit for something, put it in writing. Get an agreement. If you both have lawyers, your lawyers can exchange correspondence saying, I'm giving a $20,000 payment right now that's an unallocated payment, and we'll figure out what it applies to later, but I want a credit for that.
Okay.
And that's perfectly fine because it takes time to get all the information to know what the right thing to do is, and at least it gets some money flowing so people can live and afford their lawyers.
Perfect. Adam, I hope that answered your question. We have to move on to a couple more callers that we have here. We also want to help as many people as possible. So thank you, Adam, for your call, and we invite more people to call as well.